try to use the mic for the record. It's a pleasure, honor to share this second panel. Even more seeing that at first I am not a competition lawyer. I'm a labor lawyer, so it's even more a privilege. And it was in this quality actually to jump in the subject of the panel, that in 2018-19, if you do remember, there was this merger project Siemens-Alstom. And I was eventually blocked by the Commission in early 2019. And in this quality of labor lawyer, I had the opportunity to submit observations to the Commission on behalf of two unions, one from Alstom, the other for Siemens. And in the observation we submitted to the DG Comp, we made 3 points mostly. The first was that the remedies proposed by the two firms weren't, from the point of view of the workers, very serious. They were a bit weak. They relied on IP rights, patents, that at the day of the merger project or soon enough would have been obsolete. So it didn't seem very consistent, substantial from the point of view of the workers. The second point we made was that one of the two firms, the biggest one, was highly financialized with a high use of the back system, and this caused a threat, kind of a fear for the workers from the smallest firm, because it would have changed the way the industrial way plans organizing of the smallest firm. That was the second point. The third point was about the need for a vivid, competitive environment in the railway sector in order to overcome the green transition. That was one point made by the workers. They said, well, if you want to decarbonize the economy, we need to have a more competitive environment in the railway sector to the benefit of the workers. So this was in 2018-19. Why am I taking this example? Just to open this panel, just to show that the question of labor in the merger scrutiny is multi-layered. It's not only one layer. Of course, you've got this simple but not so simple layer of the analysis of the labor market, and see if there is a monopsony, not so simple and not so ancient. It's coming recently. But you've got other layers. One is the one shown in the example, when people, actually workers, they have a voice, they have a mind, they can speak for themselves, they can speak about the firm, the way it's going to be harmed by the merger project maybe, and so they can even speak about environment and sustainability sometimes. That's what shows the example earlier, but even more, you've got another layer. Sometimes they can be reflexive and speak about their role in the market and the role that the competition authority should have. And I wanted to take something that was of interest. Is we are in 2025 speaking about this idea of labor in the merger scrutiny, and we are here back in 1926, so one century ago. Something written by Julius Hirsch. Julius Hirsch was a former German minister of the German Reich, and it is part of a preparatory document for the World Economic Forum in 1929. So it is, and he wrote, this former German minister, there is no doubt that in the real social struggle, the formation of such monopolies worsens the position of the wage earners. Trade unions are strongest when they are faced with employers in small or medium enterprises. The fighting strength of labor is doubtless weakened by the concentration of administrative powers in the management. And then he calls for the creation of a special cartel bureau, Kartellamt. All this probably relates to the fact that labor is not a commodity, or not a commodity like the others. Offshore, there is a process of commodification, but as stated in the constitution of the ILO, the International Labour Organization, labor is not a commodity, and The great work of Karl Polanyi explains that pretty well. Well, so has antitrust failed workers, failed the citizens? It's not easy to answer. We're going to try to see if something has been lost on the way from 29. It is surprising to see that this document actually is a preparatory document for the World Economic Forum. It is, at the same time, something coming from the ILO itself, because at that time, there was no difference between both. The ILO, the League of the Nations, and the World Economic Forum was one located in Geneva. So there was kind of one cohesion, and maybe something got lost on the way, maybe after the Second World War, when the other liberals tried to imagine this independent, neutral scrutiny. Maybe, I'm not going to address this question today, but maybe to look at the reality, how to see how it works. I will first give the floor to Jebal. Jebal is from the Fédération Internationale des Artistes, and she will explain how non-price related and price related harm are created by monopolies or concentration of power in the labor market. And then we will switch to Andreas from the DG Competition, who will present the scope, the perimeter of the consultation regarding labor market, this in-depth document G. Then moving to Simon about environmental and green environmental sustainability, to have the environmental counterpart of it. And moving then away from the EU landscape, I will give the floor to Liat. Liat will explain how this South African public interest test works, maybe with more details, and that will give a great insight. And we are getting back to the EU after with the help of Joachim. Joachim is legal advisor at ETUC, the European Trade Union Confederation, and maybe he will propose some remedies to help to counter this power of the big firms, of this market power in the labor markets. I'm not giving the floor to Andreas. Andreas, you are a case handler at the DG Comp. You told me not to say anything else. Just, I think that you're going to present the scope, the perimeter of the consultation of the EU Commission relating to labor, this in-depth document G. Andreas, you've got the floor.
Yeah, thanks a lot, and thanks for having me here. Indeed, I work as a case handler in merger control in DG Comp, mainly focused on basic industries and manufacturing. But now also I work part-time on this revision of the guidelines together with Daniela. I was excited to see that he, as my boss, left the room, so I thought I could go a bit rogue in what I tell you now. But unfortunately, my other colleague Thibault has entered the room, so I'll try to stick to my script. And needless to say, any views you hear from me today are mine and not necessarily the Commission's. So indeed, I'll present the Commission's in-depth document G, specifically the part there that focuses on labor markets. And I thought I'll try to shed a bit of light on why is monopoly power on labor markets one of the topics we are seeking feedback on from stakeholders. Short answer, there is not one reason, but I'll try to give a bit of an outline of the general context. So at the European political level, for example, we see that the Commission, in its competitiveness compass, which was adopted, I think, in January this year, underlines the importance of workers' ability to flourish in quality jobs and the need of maintaining healthy competitive pressure to the benefit of companies and workers. We have the European Parliament's annual competition report, and I think in this year's edition, there's a call in there for the impact on workers to be taken into account in merger assessments. If we look at the US, we see that in their most recent review of their merger guidelines in 2023, they included a section specific to monopolies, and that section to a large extent actually deals with labor markets. We also see some recent US case practice that involves considerations on buyer power in labor markets. One, I think, prominent example is the abandoned deal between Kroger and Albertsons, so this big supermarket merger where the agency actually prominently considered potential harm to supermarket workers that this merger could have had. Here in Europe, I think we also see an increasing acknowledgement that competition policy can play a role in labor markets. There's, was already mentioned today, the recent Commission antitrust case related to no-poach agreements, the delivery hero Glovo case, which was related to a no-poach practice between the firms related to certain white-collar workers they were employing, which was the first Commission case on such no-poach agreement. On this, Executive Vice President Rivera said that this practice, which got sanctioned there in the Commission decision, reduced the opportunities for workers. Now, if we look at merger cases, we have significantly less experience here with labor issues at the Commission level. But there are some cases at national level in Europe which have touched upon this in recent years. And for example, the case already got mentioned in the previous panel under this media plurality angle, but the recent Dutch case between these two media firms, which got conditionally approved just a couple of days ago, actually also involved an investigation into whether the merger would increase the buyer power of the merged entity vis-à-vis journalists. Ultimately, I think the agency concluded that this wouldn't be the case because I think it was found that the firms weren't competing particularly closely for journalists and ultimately didn't have a significant degree of market power. But this was part of the framework of assessment that they made. And I think more in general, we see a broad range of academic literature that is assessing monopsony power on labor markets, and in particular the potential negative effects of excessive concentration on workers. There's a number of papers, for example, that look at the differences in buy-side concentration in labor markets. And what they seem to find is that just as in the US, also in Europe, a sizable share of workers is working in concentrated markets, and that this can, in principle, have negative effects in terms of wages or job opportunities, working conditions, job availability. So the research also seems to suggest that these negative effects from high labor market concentration may not affect all types of workers equally, but that concentration levels appear to be higher, for example, in rural areas than in urban labor markets, or that they are higher, that concentration levels are higher for blue-collar jobs in general than for white-collar jobs. And there's important differences also in the level of concentration between different EU member countries. So overall, there's not a singular reason why this topic was now included in our consultation on the guideline, but in light of the different sort of elements I just mentioned, it overall seemed like the right time to reflect whether it makes sense to look at labor market monopsony in some merger cases, and whether any particular specific guidance is needed by us to this effect. So it is in this context that the consultation paper finds that mergers can indeed, in principle, significantly impede competition in labor markets by shifting the balance of power between employers and workers. An increase in demand-side concentration in labor markets can, in principle, lead to lower wages, higher unemployment, worse working conditions, and also lower downstream output and higher prices. We already have some guidance in our current horizontal merger guidelines on the framework of assessment for buyer power cases. But on the one hand side, this has not been applied very often. We have run very little buyer power cases. And on the other hand side, the guidance we have is not specific to labor market considerations. So it therefore seems appropriate that the consultation seeks feedback on if, and if so, how the revised guidelines should include guidance on monopsony power on labor markets. What the consultation paper makes clear is that what cannot be addressed by the revised guidance, and in any case is also not covered by the legal mandate of the EU merger regulations, are questions around job losses that are the result of corporate restructuring. This is not then the result of market power in any specific market, and therefore is not something that can be addressed by our current legal framework. What we do, however, seek feedback on in the consultation and from stakeholders and from any of you interested in this room or with me on this panel are sort of the following questions and topics. One, do we need more and or different guidance generally compared to the guidance we already have on buyer power in the current version of the guidelines? If we look at monopsony power in labor markets specifically, some of the questions there that we are posing to stakeholders there are related to, on the one hand side, the definition of the relevant market. Now, as mentioned earlier, the market definition notice was revised quite recently, and there's no specific labor market angle in there. Nevertheless, any sort of input that you may have on how the general principles that are laid out in the market definition notice could apply to labor market cases could still be useful and helpful. Then there's the specific circumstances and conditions in markets that could give rise to problematic labor market monopsony power. And here I would invite anyone who's considering to provide us with feedback in response to our consultation to be as specific as possible. In what industries would mergers be most likely to lead to problematic levels of monopsony power that could have negative effects on workers? Are there any particular past, present, future merger cases that come to mind where the assessment of monopsony power in labor markets will be appropriate? Then any input on the types of evidence and metrics that the Commission should be using when it looks at monopsony power is of interest. And then a bit more of a fundamental legal question for anyone with interest in that is the question of whether, in order to run a monopsony power case on labor markets specifically, the Commission would also need to show that downstream consumer harm arises, or whether that is not necessary, so that the harm to workers would be sufficient. We have a precedent Commission decision on a buyer power case, my very favorite Arubis Metallo case, which is, I think, from around 5 years ago, which was a buyer power case that in the end got cleared unconditionally, where the Commission laid out that ultimately it should be possible to run a case even where consumer harm is not shown, but we understand that's still a topic that's also intensely debated, so we seek feedback also on this question. So just to summarize, in essence, we are asking both, does it matter? So is monopsony power on labor markets something that is indeed problematic in some merger cases in Europe as well, not just if we look at the US and you know, the greater number of past examples we have there, but also in Europe specifically. What are these examples? And two, if it is, how should the assessment and how can the assessment be made? So we need your help to answer all these very complicated questions, so please participate in the consultation. Deadline 3rd of September. And also after that, I think the public discussion will continue, and we look forward to continue the exchange with any of those of you interested. Thanks a lot.
Thank you very much, Andreas. This overview was very interesting. You mentioned this case recently from the Autorité de Consommation and Markt, the RTL case, mentioning that there is some question about pluralism, but about the working condition of the journalists too. It is interesting to see that it is beyond the status of employment that this work is being done, and it means that the National Competition Authority, in this case, is doing something that labor law is not anymore able to do, to establish some fairness in the labor market beyond the status of employment. Then it is something that I wanted to point out. But it's time to enough spoken about labor. It's time to move to sustainability. And Simon, you've got the floor to explain why and how it is important to take into account the environmental sustainability in the merger control.
Thanks very much, Jean-Benoit. Yes, I feel a little outnumbered on a panel that's largely concerning workers' issues, but our panel does cover environmental sustainability concerns and merger control, and that's what I'm moving to. What I want to do is say why I think the relevance of sustainability nowadays in merger control, how it can be taken into account, what the Commission has done so far, and to mention the current review of the guidelines and the consultation process in this context. The focus so far in the last few years has been very much on Article 101 and sustainability cooperation agreements, especially the need for cooperation between businesses on sustainability issues where regulation or individual action isn't sufficient, and how this can be done without infringing competition law. But we made great progress in this area, and we have guidelines from many jurisdictions, notably from the European Commission in 2023. And individual guidance in relation to projects from a number of authorities. And I would almost go as far as, well, I think can say that this is now pretty mainstream. So the focus, I think, is switching to other areas of competition law, namely sustainability and abuse of dominance, and sustainability in the context of merger control. And this is not only today's topic, but it's very much what's on the table now with the Commission's consultation. Now, I have written about this in the Journal of Antitrust Enforcement, on climate change, sustainability and competition law, also about how we can have a sustainable future, how can control of monopoly power play a part a couple of years ago. And others have written on this topic over the last few years, including those in a number of mainstream lawyers. It's not law firms. It's not just an issue that's been picked up by the academics and the NGOs. Think of articles by Nicole Carr and Linklaters and Alec Burnside at Decade. So this is, I say, it's not a mainstream issue now, but it has been something that's been out there for a few years now. And I don't want to exaggerate the importance of sustainability and merger control, or rather to put it in context. I say that because immediately you start talking about, and we saw a little bit of that in the last panel, as soon as you start talking about issues like sustainability, merger control, those representing business issues, consultants, economists, lawyers, they get very anxious. Oh God, no, we can't just wade through get our deals all cleared on narrow competition grounds. And equally, the NGOs and those representing civil society perhaps get overexcited. Merger control, perhaps that can solve some of our issues, many more of our issues. I mean, I'd make 3 points there. First of all, sustainability is only going to be relevant, I think, in a minority of mergers. They're ones that are very important to a number of us, but it's a minority. Secondly, you can't simply block a deal that doesn't raise competition concerns because you happen not to like the sustainability practice of the parties concerned. Yeah, get that. But conversely, you can't bless an anti-competitive deal because of the sustainability benefits to which it might give rise. It's much more nuanced than that. Having said it's more nuanced, I don't mean to say that these issues are completely separate. We can't just forget about the existential threat of climate change just because we happen to be we're in the office dealing with merger control. We need to consider more realistically what we mean by competition concerns. We had a discussion of that, I think, in the last time. So how can sustainability be taken into account? In my first article in this area, I suggested there were 5 ways in which sustainability, climate change, can be taken into account in a merger context. The first, and I think the most important, is in the substantive assessment, i.e., when answering the question, is there or is there not a significant impediment to effective competition? particularly looking at Article 2.1b, which was mentioned, I think, by Vanessa in the last session, which refers to the development of technical and economic progress, which is very essentially the same words as we have in the exemption provisions in Article 101, where it's well recognised that sustainability benefits are a major issue, or can be a major issue, but also because of recital 23 of the merger regulation, which says explicitly the Commission must place its appraisal of a merger within the framework of the fundamental objectives of the treaties. It refers to what I call the constitutional provisions of the treaty, which say that you have to take into account of environmental protection and the sustainable development. So there's a clear legal basis for doing this, and the Commission clearly recognises that. Sustainability can be a positive or a negative factor. It can be a positive factor tending towards the deal being cleared, a factor, I'm not saying it's a trump card, and it can be a negative factor, which tending towards the deal being blocked or being cleared subject to remedies. So that's the first way. The second issue is efficiencies. As sustainability issues can be an efficiency, but there's an asymmetry here. Sustainability can only be a positive factor there, tending towards the deal being cleared, can't be a negative factor, unlike the discussion a moment ago. Thirdly, it can be a factor in the design of remedies, helping to mitigate environmental harms or taking into account the sustainability factors in the competition assessment when designing a remedy. Fourthly, when a deal is being considered under national competition law, where the EUMR does not apply, as I mentioned earlier in the last session. National laws have all sorts of rules on public interest, which can include sustainability considerations potentially. See that most notably in the German case of the Zollern case. And then we have the non-competition tools. Actually, perhaps this point I just made fits better here, actually. The non-competition tools, again, mentioned earlier today. The legitimate interests factors of Article 21.4, sustainability could come into public security, or I would suggest it could be recognised as a legitimate interest in its own right. It hasn't been to date, but I see no reason why it could not be. And then public interest under national law. That's where I should have mentioned the Zollern case in Germany, where an apparent block of a deal was allowed by the ministry. So what's the Commission done so far? The Commission has taken sustainability into account in a number of cases, and the best summary of it, which means I don't have to do so much work or take up so much time, is the competition merger brief of September 23, which really is really excellent. In some ways, I was delighted when that came out. I thought it was in some ways an answer to many of the points I'd been making in my own work. But the Commission shows where and how sustainability can be relevant in merger control, can be relevant in market definition. Are two products really substitutable when one's more sustainable than the other? Example of that would be steel and aluminium car body parts in the Novelis Aleris case. And the answer for anybody interested was that no, they were not substitutable because of the importance of weight and the sustainability factors trying to reduce CO2 emissions and so forth. The Commission discusses how it comes into the competition assessment, particularly closeness of competition, innovation theories of harm and efficiencies. It discusses how it can be relevant in the design of remedies, and of course to the so-called green killer acquisitions, which I think somebody mentioned last time. That's the idea there being where a big, bad, unsustainable company gobbles up a sustainable company and closes down the sustainable aspect of its business. The consultation document of which is the stimulus for this conversation, very much I find very encouraging in this context. There's numerous references to sustainability, to decarbonisation and to resilience. And several of the topics upon which the Commission is consulting are very relevant. Topic A looks at competitiveness and resilience. Topic F looks at efficiencies. And most importantly, topic D looks at sustainability and clean technologies. And the latter, I think, is most encouraging. Indeed, it makes most of that. I was saying to Commission colleagues earlier, it makes many of the points that I and others have been making over the last few years. So it was very, very welcome. And it makes those points specifically, obviously, in the context of merger control. So only 3 or 4 pages, a discussion of topic D, and I'd very much commend that to you. I mentioned just two aspects to give a flavour of that. It says that mergers can be helpful to sustainability. For example, it can be helpful to the clean transition and to progress towards the climate and sustainability objectives of the Union. For example, sorry, apologies, I've got that wrong way around. Mergers can be harmful to the clean transition and hamper climate and sustainability objectives. Green killer acquisitions being an obvious example, or reducing the incentives to invest and innovate in green products and technology. But equally, conversely, they can be very positive. The opposite of green killer acquisitions, that's where a big company, say with a big distribution network, buys a smaller innovative company with sustainable products, and it wants to use that sustainable technology and roll it out over its bigger production platform and its bigger distribution network. Can also arise in the context of vertical integration with an increasingly circular use of recycled materials. The response to the consultation is the next stage. Whilst I say what the Commission's written here I found excellent in terms of guidelines and guidance, I mean, obviously, but there's specific points to be made, but generally speaking, but the devil is in the detail, or to be more specific in this context, it depends upon the practical implication of the good words that the Commission has there. And that's where the Commission comes in. The Commission's questions come in. They're looking for help in applying what it's saying. For example, it asked, how should the Commission factor in sustainability as a parameter of competition? It recognises it's a parameter of competition, but how? It asked, what types of harm can a merger do to competition in the development and supply of clean and decarbonised products and technologies, or to the circular economy? Conversely, it asks what sort of competitive benefits can a merger generate in those areas. So essentially, the Commission is seeking our help, and as Andreas says, we've got until September the 3rd to respond. I'm involved with some responses there, particularly on behalf of the International Chamber of Commerce, but I know NGOs are also responding. So here's your opportunity to input for all those interested in this area. So back to you, Jean-Benoît.
Thank you very much, Simon. We've heard earlier in the first panel the fact that it's not easy to combine different public interests, and if we do so, it will be nothing but a political choice, and then it's opening the Pandora box. And then maybe it's interesting to go more into detail to see how to do it concretely. We've spoken about the EU landscape now. Maybe it's time to move to another legal regime with the help of Liat. Liat has a PhD from King's College London, that you obtained last July. So happy birthday for your PhD. You are now a fellow at the Georgetown University. You are a fellow at the Competition Law Center at the George Washington University Law School under the guidance of William Kovacic, and you did your PhD with two very well-known examiners, Professor Eleanor Fox and Dina Wakes. This is a hybrid panel because we have people from the academic and people from the civil society. Actually, you are a hybrid person because beside your academic role, I see that you are the founder of the Social Justice Coalition, a South African human rights NGO, and you were before, maybe still, the national chairperson for a student association. Liat, you got the word to give more details about how it works in South Africa and how to include labour interest in the merger review.
Thank you very much for the very generous introduction. So unfortunately, I wasn't able to be here for most of the first panel. I was flying in from DC, but I did happen to walk in to hear a lot of criticism thrown at the South African regime about opening up Pandora's box. So I'm very excited to now address this regime. So just to begin with a word of the legal foundation. So under the Competition Act, mergers are assessed not only on their effects on competition, but also on their implication for broader public interest goals. And this is set out in Section 12A of the Act. And this requires authorities to consider whether a merger would substantially prevent or lessen competition, and if not, whether it nonetheless raises significant public interest concerns. And one such concern, explicitly identified in Section 12A(3)(b), is the effect of a merger on employment. So this framework reflects South Africa's post-apartheid constitutional vision. Competition law is not only a tool for promoting market efficiency, it is also intended to support inclusive economic transformation, protect vulnerable groups, and safeguard employment in a country with persistently high unemployment. So turning to the Walmart Massmart merger case, it was the first major test of these public interest provisions, and it came in 2010. Walmart sought to acquire a controlling stake in Massmart, a leading South African retailer. And on standard competition grounds, the merger raised no red flags. Walmart had no prior presence in South Africa, and Massmart was not dominant in any relevant market segment. But the merger sparked intense controversy due to its potential effects on employment and local suppliers. Over 500 workers were retrenched before the merger notification, allegedly as part of pre-merger restructuring. There were also serious concerns about the displacement of South African SMEs through Walmart's global supply chains, and fears that Walmart's poor labor practices elsewhere might be imported into South Africa. Stakeholders, including 3 ministers and trade unionists, intervened in the proceedings, raising public interest concerns relating to job security, treatment of workers, and supplier exclusion. The Competition Tribunal approved the merger, finding no substantial lessening of competition, but imposed limited conditions. On appeal, the Competition Appeal Court took a broader constitutional view. So while acknowledging the consumer benefits of lower prices, it emphasized the risk of destroying local supply chains, the effects this would have on SMEs, and a myriad of employment issues. So it imposed stronger public interest conditions. It included a 2-year moratorium on retrenchments, reinstatement of previously retrenched workers, and a 240 million rand, which is 12 million euros approximately, fund for local supply development and job creation. And in this way, the court was able essentially to balance, so to secure the gains of lower prices by approving the merger, while simultaneously mitigating the losses, the job losses, through Walmart creating an investment fund. So this case confirmed that employment considerations are central to merger control, even where no competition harm is found, and that public interest must be interpreted in line with constitutional values. Now, fast forward a few years to a second major test of employment provisions, the Coca-Cola Beverages South Africa case. So in 2016, the tribunal approved a merger that consolidated 4 bottlers into a single entity, Coca-Cola South Africa, subject to conditions, and a key condition being that no retrenchments occur as a result of the merger. After the merger, Coca-Cola implemented retrenchments, citing adverse economic conditions, including sugar tax and macroeconomic pressures as the cause. The unions disagreed, arguing that retrenchments violated the merger conditions, and the Commission issued a notice of apparent breach. Coca-Cola challenged this, and the tribunal agreed with Coca-Cola, finding the retrenchments were not merger-specific. The Commission appealed to the Competition Appeal Court, which overturned the tribunal's decision, taking a broader view of what counts as merger-specific. So Coca-Cola then appeals to the Constitutional Court. And here, the Constitutional Court stepped in to clarify the legal standard. It rejected the Appeal Court's expansive test. Instead, it introduced a structured causation test to determine whether retrenchments were merger-specific. So it said factual causation, would the retrenchments have occurred but for the merger? And 2, legal causation, was the merger a sufficiently direct and substantial cause of the retrenchments? And the court stressed that mere temporal or background link was insufficient. There had to be a close causal relationship. And on the facts, it found that the retrenchments were driven by external economic factors, not the merger, and upheld Coca-Cola's appeal. So crucially, the court did not undermine the power to impose employment-related conditions. Rather, it clarified that where such conditions exist, any allegation of breach must meet a clear evidentiary threshold. This approach protects both the integrity of public interest conditions and the legitimate need for firms to remain adaptive in a changing economy. The case affirmed the constitutional importance of protecting jobs, but also acknowledged the need for companies to remain responsive to economic realities. Excessive rigidity, the court warned, could undermine firm sustainability and result in greater job losses in the long run. So this decision underscores the delicate balance between corporate efficiency and social responsibility, serving as a guiding light for future merger evaluations and affirming the judiciary's commitment to upholding the public interest in economic matters. Turning now to the Competition Commission's 2023 Public Interest Guidelines. And these were developed in response to challenges raised in cases, and they provide a more structured and transparent framework for how employment issues will be assessed in merger reviews. And so there are several key features to highlight. First, employment is treated as a standalone public interest factor, separate from traditional competition concerns. It must be assessed in its own right. Second, there are strict disclosure requirements. Merging parties must declare any retrenchments that are planned, considered, or already implemented from the moment merger discussions begin, not just those that they claim are linked to the merger. Third, the Commission's primary focus is on direct job losses within the merging firms, but it may also consider indirect effects such as supply chain disruptions or outsourcing that could displace vulnerable workers. The Commission will closely scrutinize the timing of retrenchments, especially those that occur shortly before or soon after a merger. Internal company documents, strategy papers, and board minutes will all be examined to assess whether those retrenchments were part of a broader strategic alignment tied to the merger. And to determine whether employment impact is substantial, the Commission looks at the number and skill level of affected workers, re-employment prospects, especially in high unemployment regions, and the nature of the jobs involved, such as whether they're permanent or seasonal. And importantly, the burden of proof lies with the merging parties. So if they claim that job losses are not merger specific, or not merger related, they must provide convincing evidence to support that claim. So certain justifications may be accepted, such as saving a failing firm, achieving efficiencies essential to competitiveness, or showing that consumer price reductions depend on workforce adjustments. And then there's also where the employment harm is found to be both merger specific and substantial, the Commission may impose conditions to mitigate this harm. And these can include moratoriums on retrenchments, minimum headcount commitments, retrenchment caps, phased downsizing, and obligations related to reskilling, preferential re-employment, or job creation. So taken together, the guidelines codify a proactive and principled approach to protecting jobs in merger control, while remaining sensitive to broader economic realities. These guidelines are now subject to the Constitutional Court's Coca-Cola causation test. This means that while the Commission may impose conditions to mitigate employment harm, any enforcement action will require solid evidence showing that the harm is directly linked to the merger. So in sum, the South African merger regime reflects a sophisticated balancing act between corporate efficiency and public interest, especially within employment. The Walmart case focused on pre-merger job losses, showing that even pro-competitive mergers may be conditioned to protect jobs and local industry. The Coca-Cola case, by contrast, dealt with post-merger enforcement, clarifying the evidentiary threshold for proving breaches of employment conditions. Together, these cases show that employment effects can arise at different stages of the merger and trigger distinct legal responses. And the 2023 guidelines systematize the Commission's approach, providing a structured framework for assessing and addressing these concerns. So the South African experience offers at least 3 key insights for other countries, at least in my mind. So one, labor protections can be embedded into merger control, but this requires both legal authority and institutional capacity to assess and enforce. 2, the design of merger remedies matters. That must be specific, clear, and responsive to the lived realities of workers. And 3, enforcement post-approval is difficult. So labor-related conditions require precise drafting and a robust evidentiary foundation to withstand legal challenge. But importantly, there's no single model. The South African experience does show that where employment is constitutionally and statutorily recognized as a public interest concern, merger control can serve as a meaningful, if limited, site of labor protection. It offers valuable lessons on how competition regimes can reflect broader economic and social commitments, protect vulnerable workers, and remain grounded in constitutional values while still accommodating commercial realities. Thank you.
Thank you, Riyad, for this very clear explanation. And you show how public interest issues like labor is being embedded or re-embedded in the law regime in South Africa. We have to get back to the now with the help of Joachim to see if there are some kind of remedies on some better way to do for the merger control. Joachim, you are legal advisor for the ETUC, the European Trading Confederation. You have in charge the competition law, but many other subjects like the internal market, posting of workers, human rights. So you have a large overview about the EU agenda. Joachim, you've got the floor.
Thank you so much, and good afternoon also from my side. Yes, I've been asked today to talk a little bit about remedies from a trade union and worker perspective, but starting off by saying that based on what we've heard so far, I think it's quite clear that mergers do have social implications, and there's of course many tools in the toolbox on how to address them, but from the TUC side, it's quite clear that also mergers do play a role, because if we look at OECD figures, also in Europe in the past few decades, there is a concentration in the labor market, including when we look also at the decline in collective bargaining coverage in the labor market, and also if we compare the corporate profit share compared to the labor share, the wages. Now, the question when it comes to the remedies then, of course, is how to remedy the risks faced by workers in terms of less competition for their labor. That's really what it's about. And of course, we could look at structural or behavioral remedies, and I'll just start off by saying that, of course, the most effective way of preventing labor market concentration is, of course, to prohibit the merger. It's as simple as that. And in theory, of course, also a divestiture could help to preserve a multitude of employers. But in practice, what we see quite often is sell-offs or rather increases in job losses or relocations. So I'll just give 2 examples on related to this. First, the ArcelorMittal case in Luxembourg, which notified in 2017 that they wanted to buy Ilva production site in Italy. And the Commission imposed remedies, including divestment of plants in 4 countries, and our industrial trade union manufacturing sector, trade union federation at European level, Industrial, expressed concerns to the European Commission about the lack of guarantees and in terms of future production or potential job losses. They estimated that 15,000 jobs were threatened, and therefore advocated for employment and production level guarantees. But the Commission did not consider these issues as directly related to competition concerns. And as we understood also from Andreas earlier during this panel, indeed the same logic now applies also to the to the public consultation on the merger guidelines, when the Commission writes that restructuring and offshoring are not results of a change in market power and therefore will not be covered by these guidelines. But as we have also heard today, there is a possibility under the merger regulation for member states and even the European Commission to raise legitimate interests or public interests. And what we see today in European labor markets, industries, but also the political landscape is indeed also rightly referred to by Andreas, a call for European industries and good quality jobs in Europe. And this is a vision that DTUC absolutely shares, in the sense that there should be quality jobs in every region and every sector in Europe. And we do believe that also competition policy has to role to play in this, because only if we look at industry, our estimations show that every day 500 jobs on average are lost in industry in Europe today. So that is one example, and the other one I want to give is from the French competition authorities, a 2018 case of William Saurin acquisition, where remedies were proposed by the companies in terms of a sale-off of one of the production facilities, but the French government intervened by exercising their right of revocation, stating that the investment could cause significant impact on employment. We were talking about 1,500 jobs in a region with quite high unemployment rates and few opportunities of retraining. So in the end, what happened is that the merger was cleared after all, but with a commitment that William Saurin would maintain all jobs for a period of at least 24 months. So this brings me to the issue of not the structural remedies, but rather the possibility of also having behavioral remedies, because as already demonstrated in principle, these could include, for example, commitments to preserve jobs, or avoid plant closures for a period given post-merger. Also, job losses could be mitigated through various means, for example, in terms of commitments for reskilling or upskilling of the workforce to make it easier for them to find an alternative jobs. We could also look at the buyer in case of a structural remedy, the divestiture buyer. What kind of requirements do we have on them, not only financially, but also in terms of social viability? Another important point I would like to make today is the issue of collective bargaining coverage and union presence. Like, to put it quite simply, what happens if we have a merger and one company has a collective agreement and the other one does not? Could there be a commitment to maintain the collective bargaining coverage and to ensure the union presence and the workers' representativeness on the future work sites also? Because, as also explained by Derbal during her intervention, when it comes to labor market monopsony, the most important rebalancing function in the labor market is collective bargaining. That's the collective power that workers have to face the employer and to prevent a downward pressure on wages and working conditions. So in terms of behavioral remedy, this is absolutely something we believe that should be considered in the same way as, for example, requiring transparency on the hiring or pay practices. And finally, also, for example, in terms of joint monitoring mechanism, trade unions are the eyes and ears on the ground in a work site, because these behavioral remedies, of course, not only need to be imposed, but also respected. And unions have daily access to the workplace. So this very easily enables them to flag compliance with the remedies or not. We could be talking about unlawful layoffs or hiring freezes or contract erosions, for example. And going one step back, I think unions also have a role to play, not only in the design of or monitoring of these remedies and what they could look like, but also the really from the beginning making sure that the voice of unions are heard in the process. Of course, trade unions can intervene in a merger case as a concerned party through a third-party intervention, but in our view, the unions should always be heard because they know the sectors, they know the structure of the company, they know what kind of implications a structural or behavioral remedy could have on the work site. And there are also, even at European level, there are information and consultation rights EU directives, but our practical experience from national affiliates is that there's sometimes also a tension between the merger deadlines, that it's a quite speedy process, and the rights of workers to be informed and consulted, because we have cases where trade union reps find out about the commitments made by the company through the media and not through the consultation channels. And we feel that also perhaps the European Commission should be more stringent in making sure that DG let's say, asking themselves whether now has the information and consultation rights, though basically the policy areas of DG employment, been complied with, or are we just rushing this through? So these are absolutely things to consider, we believe. Thank you.
Thank you very much, Joachim. Your toolkit doesn't really seem like a Pandora box. In my view, it's you were covering many of the points raised by Liat. One was the enforcement post-merger review. It is now late. It's time to get some questions from the floor because we run out of time. Then, if anybody has a question, please look at one there. Maybe one question here, and at the then after, yes.
So very briefly, I think it's quite interesting to contrast social and environmental sustainability in the situation in the EU and the US. In the EU, we have been very open. I mean, it was a political choice, I think, in favor of environmental sustainability. Labor hasn't been that present. In the US, it's a little bit the opposite. So the merger guidelines 2023 have been about labor, not much about sustainability. What I'm saying is that political choice is everywhere, and it's not that some things are political choice, some things not. Everything is a political choice at the end. Secondly, I basically wanted to ask Andrea. One of the important issues now is to see if restrictions of competition on labor markets alone could justify some concerns with regards to the merger. And we don't have, obviously, experience in merger control, but I do have some cases and some opinions, basically, of advocate generals in the context of abuse or Article 101 cases, and in particular Article 101 cases. And what I found interesting is the opinion of Advocate General Emilio in Tondela, which concerns the no-poach agreement, basically finding that this, to the extent that it affects labor markets, it could be considered theoretically as a by-object restriction, but then saying that because this specific agreement, no-poach agreement, was basically done to ensure that the rich clubs will not be able to use, to buy basically, to get in a buying spree of players, and that will affect somehow, the consumers to the extent that, that is certainly something that was, so somehow insinuated that there should have been some form of, in the analysis, a consumer impact, right? And I think the situation is easier when you have monopsony. And by the way, the Greek authority was one of the first also that dealt with a merger with regards to labor markets and monopsony. The Delivery Hero merger, actually, in the Greek islands was about a delivery sector. But then, the situation, so there is kind of an efficiency issue. But but you don't not only rely on monopsony models, you might have also bargaining models that might lead to negative effects on the consumers, but these are more distributive effects. It's not like the output is going to be reduced, it's basically that is going to be a transfer from the laborers basically to the parties having bargaining power. So my question is, are you be consistent with, what is your thing with regards to merger control vis-a-vis the case law that you have in 101, 102, and how this evolves? And I think I'll stop here because there are other people that might want to ask questions. Maybe we can take more questions. Yeah. We take more? Yeah.
Hi, Tono Hill from PAR. I actually had two questions, if I may. First one, Joachim, your example of the French conditions on 2018 made me think of something, which is of the safety net that sometimes countries can provide when it comes to conditions, when it comes to employment. I'm thinking, for example, in Spain. Right now, we just had the Spanish government intervene on public interest grounds on BBVA Sabadell banking merger. If they wanted to, they could have imposed conditions on employment as well, but that's because it came from the CNMC. Take, for example, Orange MásMóvil, another Spanish merger, but that was dealt with by the European Commission. In those cases, I think the safety net of a national government, depending on the national legislation, imposing some conditions on employment is lost. Does that mean that there's extra weight on the shoulders of the Commission to bear that burden when it comes to labor conditions? That's one. The other one is kind of to play devil's advocate a bit. I've heard some people saying that there's this sort of tension between the worsening of conditions, a merger resulting in the worsening of conditions for workers, but at the same time, that same worsening of conditions could result in lower prices. How do you resolve that kind of tension? Do you think there's a tension at all there? Yes.
Thank you. So my question is to Professor Simon and more on environmental. So I was going to ask this before, so please, Professor Wolf and Ioannis, feel free to, if you want to jump in. But I was going to ask, when competition authorities were editing guidelines regarding cooperations between competitors, one major discussion revolved around whether consumers within the relevant market should be compensated. I was wondering, as I was hearing you talk about efficiency, remedies, market definition as aspects that could be considered for the merger guidelines, if you think there are elements outside the consumer welfare standard or what is already in the guidelines that should be considered, or if these factors that you mentioned should be revised in a way that is very bit distant from what exists right now, such as the discussion specifically for environmental agreements that could make an exception for compensating consumers, for example.
Thank you. Maybe Andreas for the first and the second question, if you are.
Yeah, I can say a couple of words. First of all, what I should have mentioned at the outset, I'm also not a competition lawyer, so take anything I say with an extra grain of salt. But obviously, I mean, the issues you raise are, I think, real and something that, you know, in the process of the consultation, we look for feedback on. Obviously, in merger control, our standard of harm is a bit of a different one than in the other instruments you raised. And I think in practice, ultimately, in many cases where potentially harm on labor markets could arise, you would also find directly or indirectly some form of consumer harm. Directly because either the companies are also have market power in some sort of product market, or indirectly because I think research also shows that bargaining power of workers, labor mobility, etc., also contributes to things like innovation, etc., which ultimately benefits consumers as well. So I guess you could argue it depends whether you go the short route or the more indirect route, but ultimately harm to workers, I think, can in many cases have result in harm to consumers as well. Now, the case, the question you raised on how do you do the balancing if you have a case where the increase in bargaining power vis-à-vis workers may actually lead to lower downstream prices. I don't have a good answer now. I mean, obviously, sometimes we already have to do this type of balancing even today in certain cases where you may have a certain market where harm arises to the relevant customers in that market, but in another market the merger may even give rise to benefits. Dare I say the word efficiencies? So that sometimes you have to do this balancing. I think it's not and wouldn't be entirely new, but yeah, wouldn't be an easy choice to make in this case.
Hi, thanks for your question. It raises a number of issues. I'll make 2 points or comment on two aspects of what you said. One is the reference to consumers being fully compensated, which is something that comes up particularly, as you say, in the cooperation agreements. 2 points there. One, I think that is simply wrong in law. It's in the Commission's repeated it in its guidelines still, unfortunately, but the law says unequivocally that the consumers must have a fair share. Not that they must have the whole lot of the benefits, a fair share, not fully compensated. It's also totally inconsistent with the idea of the polluter pays principle, which means exactly what it says. Those who make a mess clear it up, as somebody put it recently. And the second point, you mentioned consumer welfare. We could talk about that for ages. There's far too much written on it. My 2 points are, one, that is not what the law says. There is not a reference to consumer welfare in the treaty. So that's why I continually refer to what the treaty actually says when I'm talking about cooperation agreements, and it's why when I'm talking about the merger regulation, I referred to Article 2(1)(b), where the Commission, and as does the Commission, which refers to the development of technical and economic progress. So first of all, let's focus on the law, not these abstract ideas that have crossed the Atlantic some years ago with some rather right-wing economists. Having said all that, as I tried it, it's an unwanted import. But secondly, if it were what the law said, what's wrong with consumer welfare properly construed? Any sensible approach, ask any man in the street or woman in the street what consumer welfare is, and it's quite capable of encompassing consumers having clean air to breathe or enough food to eat. It's only when you get into the sort of narrow antitrust box that you start confining consumer welfare to something like price effects.
Sorry. Thank you very much, Simon, for this last word. It's time to thank all 5 panelists. It wasn't an easy task to try to translate the public interest into legal consideration, legal framework, to re-embed the public interest. Many thanks. Time for a break, I think.